Today we're going to talk about temporary employees, why businesses use them, and whether they realize it or not, the potential liability that comes along with using temps. And we're also going to talk about what to do about that then, our suggestions and recommendations. Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
I love this topic so much that we've done it several times. This one's going to be a little different, to be fair.
We've definitely talked about temps a
Yes.
lot of times, but I will say I recently have had several discrimination charges, some lawsuits, also questions and concerns about what it means to have a temp assigned to work for us.
Yeah.
And whether they can then bring claims against an organization.
This to me reminds me of what they call in the biz an evergreen topic. Right? We can play this 20 years from now.
It'll still be the same thing.
A lot of people will still be surprised about what we have to say. So we're saying it again. Again, this is going to be a little different. We're going to get into some practicalities here that we have not talked about before. But it's always good to level set at the beginning of a conversation about temps, right? Because I just dealt with a lawsuit recently. Whenever we get a charge or a lawsuit, and to be clear, we most often represent the employer where a temp is placed, although we do represent some placement agencies.
Right.
But most people listening, right, are the employers that hire temps. And then there's a lawsuit, a discrimination lawsuit, let's say, that names the employer. And what is the first question we get from the client? Every time. It is, well, they can't file a charge or file a lawsuit against us, right? Right.
They're not our fill in the blank
Employee.
That's right.
Why, and then sometimes followed, that's why we used a temp agency.
That's why we used a temp agency.
Right? Because we thought we weren't getting an employee with all the stuff that comes with that employment relationship, the web.
That's right.
Right? That comes with that employment relationship. We thought that was all on the placement agency, right? And then we have to deliver the unfortunate news.
The really unfortunate news. And I just want to say, it's not our fault.
No, we're just the messengers.
We're just the messengers. We then have to talk about this thing called joint employment.
Right.
A joint employment relationship, right? And what that says, as you know, is when there is a placement agency who has hired people, okay, and then places them to provide services in other businesses, there typically is a joint employment relationship, meaning the temporary service agency is that person's employer. And also the business where they're assigned to work is their employer as well for the purposes of employment discrimination statutes, the FMLA,
Fair Labor Standards Act,
Fair Labor Standards Act,
lots of employment.
OSHA, MyOSHA, etc. So let's just talk about that for a minute, though. Rebecca, what has to be true about that placement for that business to be a joint employer for a temporary employee?
So that question can be complicated. I'm going to explain why it can be complicated, and then we're going to simplify it for folks.
Perfect.
The reality is it depends which law you're talking about.
Right.
Right? Because the Fair Labor Standards Act, for instance, defines joint employment a certain way.
The FMLA
right?
does, I
the
know.
FMLA
Title
does.
VII
Title
does.
VII. So part of it, right, depends, well, which law are you asking about? But most of them have one thing in common. So to simplify the conversation, the first thing I usually would ask the employer about is who has control and supervisory responsibility over the day-to-day work of the temp.
Right.
And you said it's typically a joint employer relationship because oftentimes, right, the employer supervisors, right, are giving the direction, the work assignments, supervising the quality.
That's why they're the supervisors. They're literally the supervisor, right? So right.
But not always, right? So sometimes I know of situations where the temp agency sends a supervisor, right, to watch, to supervise the employees that are placed there. I've known of other situations where a temp agency sends someone where the nature of the assignment is described, right? That the work that needs to be completed is described, but there's no one giving direction because that person knows exactly what to do, right?
Okay.
And they're just sent out. Maybe
It's almost like an independent contractor
it almost
relationship.
is, except that's the opposite.
Okay.
Right.
got
So
it.
if it's a temp employee, right, it's like an independent contractor relationship versus an employee relationship.
Okay.
The analysis over control is quite similar.
So let's take what I think is the most common
Okay.
situation.
Yeah.
And that is employer, business decides that they're going to utilize temps to either fill a need, right? A business need. They had a big order come in,
Right,
and so they don't
exactly.
have enough regular staff to fill the order, or oftentimes they're using something called temp to hire.
Yeah.
So
Yeah, I see a lot of that.
they're having temps assigned to them as kind of a trial period to
Right.
see how they do, and if they make it as a temp for a certain period of time, then they might be offered a job there, right?
Correct. Yep.
In both of those situations, most commonly, the temp agency has the people, they pay the people,
Yep.
right? They're
Yep.
in charge of payroll.
Yep.
But they assign them to work at, let's say, Miller Johnson. And then they show up to work at Miller Johnson, and Miller Johnson takes it from there,
Yep.
right? Miller
does happen a
Johnson
lot.
says, Sarah, here's the work you're going to be doing. Here's how you do it. Here's the person who's going to direct your work. Here's who you should tell if you have any concerns or have any questions, etc. And then Miller Johnson oversees Sarah's work when she's there as a temp.
Right.
Okay. So in that situation, that is almost certainly going to be a joint employment situation,
Correct.
meaning Sarah is an employee both of the temp agency and Miller Johnson.
Yeah, for doing the exact same work. That is a concept, frankly, that some people have a hard time getting their heads around. That the employee, the individual, right, can go in and do an hour of work and have two employers in that same
Right.
hour.
So Sarah, if she believes she was discriminated against or otherwise treated unlawfully
Yes.
during that assignment, Sarah can file a claim against the temp agency, can file a claim against Miller Johnson, or can file a claim against both.
Yep, absolutely. You're not off the hook because it's a
Okay.
temp agency employee. So that is something that continues to befuddle. And again, we're just the messengers here, right? We didn't
Yes.
create this situation, but that's something we've described in the past. But yet, right, we need to repeat again.
Well, we do, because I still think some of the people listening to this, that might be a revelation to them to understand. Because here's the deal. That then means that your temps can make claims of discrimination, right?
Yeah. Yep. So
And so many businesses and HR folks have developed certain practices to make sure they've got a solid foundation to explain their decision-making process
Yep.
should an employee make a claim of discrimination,
yes.
right?
Yep.
Those processes largely do not exist for temps.
And that's the risk factor.
That's where the
Right.
rub is, right?
All of our good processes, right, fall apart. They just don't apply. People just assume they don't apply.
That's right.
So let's pivot then to the practical. Okay, so now that people have gotten their heads around the fact that they may be employers in some situations under various employment laws of temp
And
agency
can be liable for decisions.
Absolutely, including, let's just talk about one decision and then we'll get into the practical, right? I think that's what everyone wants to know. So
What do I
what
do?
do we do? Okay, that's a scary fact for Rebecca.
Right.
But what do you want me to do about it? We are going to talk about that in a minute. But I just want to talk about one of those decisions that a lot of employers don't even think is a decision. When the supervisor calls the temp agency, doesn't talk to the employee,
Right.
contacts the temp agency and says, please don't send Sarah back
Right. Please end this
to
assignment.
Miller Johnson,
Yep.
right? She's too short.
And old.
And height is a protected status. And as you can see, I got another Easter egg there for people to know. Height and weight are. I've never had a short case or tall case.
No.
But this may be our first. Okay. Sarah is too short. We don't like the fact that she's short.
Right.
Please do not send her back. We're not telling you to fire her. You can send her to one of your other placements. We're just saying, don't send her here. And then when we get the claim, almost first, when they get their heads around the joint employment concept, the next thing is, well, we didn't fire her.
We didn't take an adverse action against Sarah, right? So ending that assignment is an adverse action.
Yes. That's surprising to a lot of people.
Again, that's a revelation to many businesses when they realize that ending an individual's temporary assignment is akin to actually ending somebody's employment.
Yes.
But the processes that businesses follow for those two things couldn't be more different. Usually, it's like night and day.
But I think that's square one, don't you? Because I don't think a lot of employers consider that an adverse employment action.
Right.
That's why they haven't gone through the processes that they know are best practice.
Right.
Right? Because they said, we're just sending them back we're just saying we don't want them placed
We're just
here.
releasing them. We're not firing them, right?
Yes, turned away is another way
right, exactly.
of putting it.
So I think that's right. And I want to pause here because I think now we're going to talk about our practical advice, right? And I just want to say we are mindful that there is often there are practical and administrative reasons that businesses use temps. Okay. So we need to balance those reasons with some ability to protect against potential liability.
Right.
Does that make sense? Right. So it would be easy for us to say, well, just follow the same process for temps than you do all employees. But I think that's unworkable, don't you?
Well, it depends on the specific situation, but in many cases, employers may use temps for speed.
Yes.
We don't have time for all the onboarding, orientation, the training modules, etc.
Yeah.
We've got an order that needs to be filled.
Yes.
Right? We need a whole third shift worth of folks right here tomorrow.
Right.
Type of thing. And also their internal resources.
Right.
We don't have the HR resources to recruit, to onboard, to to do all of those things. So we're going to use a temp agency. And if that's true, either of those are true, going through the regular onboarding, training, all of that just doesn't make sense.
And also the progressive discipline process when maybe a temp isn't performing well, et cetera, right? So in other words, we understand that the reason why a business might use a temp plays into what sort of efforts it makes sense to put forth to avoid liability for temps, right? So we're looking for a middle ground here, right? We're looking for solutions that both recognize the expediency of temps, but also help the organization should they then have to respond to a charge or a lawsuit by a temp. Does that make sense?
It does. Right.
So in thinking about it that way, the first recommendation that I would have is that there is some level of HR oversight in decisions to release temps.
Okay.
I often see supervisors being given authority to make those decisions with no oversight whatsoever, and that's in workplaces where a supervisor would never have that ability to end somebody's employment. And coupled with the fact that the supervisor doesn't understand they're making a decision that has legal implications, right? So it's being made by somebody that doesn't typically have the authority to do it, and also doesn't have the knowledge and the training to understand the impact of what they're doing.
Right. So to break that down, though, just a little bit, because some people may have just gotten a little nervous. For organizations that have like multi-step discipline processes before you reach termination, we're not saying you have to go through all of that before getting to termination.
No.
Right? That's not what HR is looking for.
No.
Did they get a step 1? Did they get a step 2? Did they get a step 3? Right? It's not that.
No, I'm looking for only this. is there a legitimate non-discriminatory basis for this decision? And are we sure that there aren't other concerns, maybe under the FMLA, for example, right? That issue, so number one, what's the reason? Do we feel comfortable with the reason? And number two, that basic issue spotting that our HR listeners know so well.
Yes.
Right? That's it.
It's okay to have a different process and maybe a shorter process for temporary employees versus regular employees. That is okay, so long as you're not applying the process based on that fact alone.
Right.
That one's a temp.
Right.
And one is not. Obviously, we can't do that, right, based on protected characteristics, which makes HR folks nervous to have different processes for different employees.
But you absolutely can for temps.
Yes, okay, good.
Well, and let's be clear, they do now. I mean, there already is different processes in place for temps or now.
They do, but they could have heard to the first 5 minutes of this, Sarah, and now thinking, well, Sarah and Rebecca are saying, right, they're employees.
Right,
And employees get 4 steps and on it.
Yeah, so that would be my first, probably most important recommendation, is some level of HR oversight with regard to the release of temps.
Completely agree.
My second recommendation is this. I see a gap in which temps are employees under many laws, but we're not having them sign off on the policies that benefit the organization from a legal standpoint. The biggest example that I see is the harassment policy
That's
and
the
the
one.
EEO policy. Okay? So those policies can provide a defense to harassment claims and discrimination claims. Sometimes if we provide a path for them to make a complaint and they don't do it,
Right.
we don't have temps sign those things.
I know.
Okay? So again, let's talk about middle ground here.
Right.
I'm not suggesting that we put them through rigorous training. I'm not suggesting we give temps a copy of our entire employee handbook and have them sign off on it. But what we've done frequently for employers is put together a very short, couple of page sort of packet of the most important things to provide temps, and having them sign that as part of their onboarding process.
Yes, we have like a best practice packet,
Yes.
right, for temps,
Yes,
right?
exactly.
Things, as you said, EEO, harassment, workplace safety.
Workplace
for
safety
instance,
is a
workplace
big one.
violence, those sorts of things.
Workplace threats, workplace violence.
Right.
If solicitation is important, temps are often can be used as salts in a union setting. So those types of policies, just a little packet, have them sign off on that stuff.
Yep, good idea. I completely agree. So let's talk now about the agreements between the employer and the temp agency.
Yeah.
So something has gone wrong. Well, let's get before something has gone wrong.
Right.
We've got 2 totally separate organizations that are both considered the employer, perhaps, under certain employment laws. Well, who's doing what?
Right.
Who's doing what? And that's the purpose of a good agreement in any context, right? Is just so there's a meeting of the minds,
Yeah.
right? So both sides really understands what they're asking of the other. So there can be some play here, there can be some negotiation here, but typically representing the employer's side, right, we would want the temp agency to take responsibility for overtime, for instance.
Sure,
right,
any
paying
wage
overtime
issue,
correctly,
the
any
payment
wage
of
issues.
wages, FMLA, making sure that if this individual has worked for the temp agency for long enough to be eligible, or even for us for long enough, that it's the temp agency who is responsible for sending the required notices and making sure we're complying with the FMLA.
What about workers' comp, Sarah?
Yeah, who's got the workers' comp coverage?
Who are they covered by? They got to be covered. They should be covered by one of the organizations whose workers' comp policy is going to control, et cetera.
You got it.
Yeah.
You got it. That's exactly right. And I mean, larger and more sophisticated temp agencies have have agreements
Yeah.
that have been drafted, and often drafted by lawyers. Smaller temp agencies, I've seen situations in which there's no agreement at all.
Yeah. Or they're very, or
and
they
that's a
just,
problem.
or they just deal with payment,
Yes.
right? Whatever you're paying the employee, we're going to do $1.50, right? Surcharge, you'll pay us every week, blah, blah.
Yeah.
It has to do with, we want to make sure we're getting paid,
Right.
right? It has nothing to do with these other
Exactly.
matters. I've seen
Exactly.
those.
And in those agreements, they should make clear who's responsible practically for complying with what laws, but also then have what's called an indemnification clause.
Yes, indemnification is another one of those words that only
Right.
lawyers use. But what that means is if you took responsibility for doing something
Yeah.
and you didn't do it correctly, or someone alleges that it was not done correctly, you will own that problem. That's like a layman's way of
Yes.
saying that. You own it. And if they sue me, you will cover that for me.
Exactly.
Because that was your responsibility.
You got it.
Right. We have a
got
whole
it.
practice group on insurance coverage.
Yes.
Indemnification, litigation is a whole
Right.
practice area. They would strangle me if they heard that very simple description, but that's basically it. And of course, everyone listening understands why that's important in a situation like this, to have a temp agency indemnify the employer for employment errors, payroll errors, etc.
things like that.
Especially if they've taken ownership of that in the agreement,
You got it.
right? That can really save the day, frankly, financially.
Yes.
Okay, well, I think that's all for this episode of Temps. Wait a minute, it's off the clock.
Join us for our next episode of No, just kidding. No.
Have a good day.
Yeah, thanks, Rebecca.